breach of the competence conferred on it by the arbitration agreement, whether by deciding in excess of or by failing to exercise its jurisdiction. Again, please note the absence of any reference to judicial review based for errors of fact. Now we then, as I explained already, have the 1965 ICSID Convention. But if you look back through history, we simply don't see a track record where disputes between states in relation to awards are required to give rise to any appellate mechanism on errors of fact. And I query whether there is, notwithstanding the apparent injustice of certain cases, any appetite for states to subject themselves to such a review. Of course, if a state loses a case at first instance, it will say it wants an appeal. Like Mrs. May in England now is very keen on the appeal to the UK Supreme Court. But I can guarantee if she had won before the divisional court, like every litigant, she would be dead against any form of appeal. Now, more recently, and this is where it gets much more interesting, there have been several efforts to introduce an appellate system for ISDS awards made between states and foreign investors, i.e. ISDS. The first initiative was taken by the USA with its Trade Act of 2002, which mandated that future US trade agreements should have an appellate body or a similar mechanism. This led to the USA's free trade agreements with Chile and Singapore, both providing as a placemaker for the eventual establishment of an appellate body, if and when agreed by the contracting parties. It has not been so agreed. In 2004, the USA's new bond model BIT contained a similar provision for the possibility of a separate multilateral agreement between states establishing an appellate body. In 2004, we had CAFTA, again with a placemaker providing for the possibility in the uncertain future of an international appellate court for indecent disputes. Now, all these proposals have come to nothing. Later, in 2004, ICSID presented its own suggested reforms to investor-state arbitration, which included a proposal to have ICSID appeals facility rules, by analogy with the ICSID additional facility rules, so as to foster, in its words, coherence and consistency in case law emerging under investment treaties, and to enhance the acceptability of investor-state arbitration. Now, this is fairly familiar, as you will hear. The appeal body would have 15 persons of different nationalities, from which 3 persons would be formed for each appeal, each subject to a term of 3 to 6 years. An award could be challenged for, in ICSID's words, a clear error of law, a serious error of fact, or any of the 5 grounds of annulment under Article 52 of the ICSID Convention. Such an appeal would be an exclusive remedy, ousting the possibility of any recourse before a state court under a national law. An appeal would require the appellant to provide security for the amount of the award. The appeal body would have wide powers. It could uphold, modify, reverse, annul the award, or remit the case to the arbitration tribunal, or even to a new arbitration tribunal. These proposals came to nothing. They were considered by many states and investors to be both unwelcome and premature. And so in 2005, ICSID abandoned its proposals. Later in 2007-2008, the OECD also proposed an appellate mechanism, convening a conference by states in Paris on new proposals for an appellate body. It failed, notwithstanding the USA's strong endorsement. The principal opposition to these proposals came from European states, particularly the United Kingdom. At that time, having abolished the traditional special case for arbitration awards made in England under the Arbitration Act 1979, and imposed still further restrictions on judicial review for errors of English law under the Arbitration Act 1996, the UK's delegates were not favourably inclined to support a new appellate system permitting any appeal for errors of fact. In 2012, not discouraged, the USA Model BIT again included a provision for the possible creation of an appellate mechanism. In 2013, UNCTAD proposed its own appellate mechanism, but that proposal also came to nothing. So now we have the proposal by the European Commission. And what the Commission proposes is a limited appeal on fact, but not for any error of fact, and for an error of international law, but not any national or regional law. The factual error must be, under the EU's wording, manifest. You'll recall that ICSID's earlier proposal in 2004 required the factual error to have been serious. Now, the difference between manifest and serious is doubtless subtle, but could it work in practice, whatever it means? We can guess that the Commission took the award manifest from the ICSID Convention of 1965, where that word is used in several different contexts, but none relating to factual or legal errors. Would we say that the scientific errors in the award in the Brady case were manifest or serious, or, to use the appellate court's wording, at most a mistake of fact, where the arbitrator acted within the bounds of his jurisdiction? The danger would always exist that what was manifest or serious to one appellate person would not be manifest or serious to another appellate person. And this categorization of factual errors cannot be equated to arithmetical errors. They are essentially subjective. And a finding of fact usually depends upon an assessment of conflicting evidence. And the suggestion that a manifest or a clear or serious error of fact can be easily identified is likely to be an illusion in practice. So the true choice lies between a full general appeal on facts, as exists in many legal systems, or an appeal on law only. And as history has shown us, a general appeal on fact cannot be done with an arbitration tribunal. It's inimical to the concept of arbitration. Now, could it be achieved with an international appellate court, particularly an established international court such as the ICJ? Well, the experience of the ICJ suggests that this is unlikely to be attractive to states, or even work in practice. So despite the apparent strength of the argument based on justice is unlikely to support the Commission's proposal. So I suggest we put a cross against this first box of justice. Let's turn to the second, consistency. The benefit of an appellate system is said to be consistency of decision, even where international law has no system of stare decisis or binding precedent outside a particular case. Now, the siren song attacking the inconsistency of ISDS awards has been sung with increasing frequency in recent times, with the same well-known cases recited like a broken gramophone. We can start with the fate of the Argentinian cases before differently constituted ICSID ad hoc annulment committees. In theory, it is of course axiomatic, but as confirmed by many ICSID annulment committees, the role of an ICSID annulment committee under Article 52 of the Convention is not to review the decisions in the arbitral tribunal's award, still less to substitute its own views for those of the tribunal. The annulment procedure on Article 52 addresses only the fundamental integrity of the tribunal and its jurisdiction, its procedures, and the form of its award, and is not concerned with the merits or mere errors of fact or law. So as decided by the ICSID committee in CDC and Seychelles, citing Professor David Caron's well-known work with approval, annulment is concerned with the legitimacy of the process of decision rather than the substantive correctness of the decision. Yet ICSID annulment committees have produced three very different results in CMS Argentina, SEMPRA Argentina, and Enron in Argentina. In SEMPRA, the ICSID annulment committee decided that the arbitration tribunal had made a fundamental error, a nullable error, in failing to apply to the issue of necessity Article 11 of the USA Argentina BIT, and conversely in wrongly applying customary international law as codified in Article 25 of the ILC articles. And earlier in CMS, a different annulment committee had criticized but had not annulled an award under the same BIT on similar facts decided on similar grounds. And later in Enron, a third annulment committee annulled an award also under the same BIT on similar facts for failing to apply customary international law that the SEMPRA committee had found illegitimate. And Professor Alvarez wrote in his Hague Lectures in 2011, these results confuse instead of providing consistent guidance to future arbitrators, investors and states. the decisions send decisively mixed messages about the nature of the annulment process. I could add other examples of inconsistent awards, and doubtless you could add many more. Yet I question whether we have a real problem of inconsistency. There is no systemic inconsistency. Awards are published, the proceedings are transparent, and there is a thriving debate, which arbitrators know only too well, over the outliers in academic and professional circles. And even if there were inconsistencies, would it be cured by an appellate mechanism, such as the Commission proposals? Of course, there would then have to be a system of binding precedent, going beyond the particular case. But how could that be achieved in a system with so many different forms of the ISDS and several international tribunals applying similar legal rules with no system of precedent? Where angels fear to tread, as they do before the ICJ, lesser mortals should take heed. Consistency will not be easily or quickly achieved by any new appellate mechanism as suggested by the Commission. And it may also create new difficulties if the appellate mechanism makes so-called bad decisions of its own, which are binding in future disputes between other users and before other tribunals. So again, I would put a cross against this second factor. So I now come to the third and last, which can be dealt with more shortly, because we can deal with it in the context of an incident in the arbitration between the Lowen claimants and the USA in the first arbitration brought against the USA under Chapter 11 of NAFTA, decided in 2003. After the award was published and the tribunal was seemingly functus officio, one of the former arbitrators spoke freely about his first experience as a NAFTA arbitrator at a public symposium at Pace University in New York on the 8th of December 2004. Now, the Lowen concerned, as you will recall, an alleged denial of justice under NAFTA and international law inflicted upon two Canadian investors by a local plaintiff, his counsel, and a state court judge in Mississippi sitting with a local jury. The foreign investors' complaints were eventually dismissed by the NAFTA tribunal on jurisdictional and other technical grounds unanimously. But on the facts, the NAFTA tribunal expressed in trenchant terms its distaste at the unfairness of the trial in Mississippi as conducted by the state judge and counsel for the local plaintiff in shocking, xenophobic, and even racist terms. The name of this indiscreet former NAFTA arbitrator, Judge Abner Mikva, is public because his discourse was tape recorded, and what he said at the beginning about his appointment as a co-arbitrator by the USA's Department of Justice has been the subject of much academic comment. And none of that criticism is relevant here, and I don't seek to criticize Judge Mikva. It's necessary to bear in mind, in what I read next, that Judge Mikva is a very distinguished and senior jurist in the USA who has served in all three branches of the US government, Congress for 5 terms, the US Court of Appeals for the District of Columbia in Washington for 15 years, and counsel to the US President, namely President Bill Clinton. And as a US Congressman, significantly, he recalled that he had voted in favor of NAFTA, including Chapter 11 on investment protection and ISDS. Despite that extensive experience as a US private and constitutional lawyer, Judge Mikva readily admitted that he was not an international lawyer or a specialist in international investment arbitration. But this is what he said at the end of his frank discourse about his first experience as a NAFTA international arbitrator, sitting with his 2 British and Australian co-arbitrators in the Lowen arbitration. It's a long quotation, but it merits citing in full. He said this: "Most of the time we were hearing people, and by that I think he meant the expert witnesses who were called in the arbitration, including the then Professor Christopher Greenwood. Most of the time we were hearing people know not that they don't know anything, but they don't care anything about this delicate separation of powers that we have in this country and the unique role that the US state court system and the federal court system play with each other, because they were looking at international law norms They were looking at what constituted